Okay, I shall not say a word on your papers. Since we have recording going on, we'll soon start. So Michael, I'll just do a brief introduction, a quick recap, a brief introduction, and hand over to you. Towards the end, a few minutes before you end, we would just tell us when you want us to run the poll. We would put up the poll, and yeah.
We're going to try to finish pretty punctually at 12:30. So I think maybe if we ran the poll 10 minutes before that, then it would give everyone an opportunity to give a few closing comments.
We will do that. I think we will do that. Are you planning to take some questions?
I hope so, certainly.
Okay. Are you sharing, is anybody sharing their screen? And you've checked out all of that? Perfect. Yeah, it doesn't, Fatma, can you please send me your slides? Can you just email a copy to me so that we can also upload it and be sure that?
Sure, absolutely.
Thank you very much.
Yeah, very good.
So all your people, Michael, they're all ready to join, and all the mediation people are like, who want to attend our panel. I'm like, we're all one, you know, but anyway, we'll see all your mediation people. They're very excited.
Okay, shall I start by introducing?
Let's give them 1 more minute.
Okay, fine.
Then I would introduce you and then hand over to you, if that's okay. I think we've started, yeah, we're recording, so we're good. And you can always take back your 5 minutes that we took from the panel, so that's fine. So thank you to those of you who have moved over from panel 3 to panel 4. We're gradually getting there, we're almost done. And welcome to panel 4. Welcome to our mediation group. From the keynote I gave not keynote, the welcome address I gave yesterday, I mentioned this group that formed as an offshoot from our conferences. And so they're a fresh group. They formed last year in Douala. That was when they came together as a mediation group. And I would also invite again, all of you who are mediation enthusiasts to please join the group. And this is their panel. They organize themselves. We just tell them what date and time, and then they sort out their program. They get their speakers. They do all of that, for which Michael, Hero, Caroline, the co-leads for this group. I am very grateful, and we'll continue to work together. And so it's I'd like to introduce the moderator. As we've been saying in all our panels, all the bios for the moderator and the speakers are on the conference website. I'm going to put it again in the chat to make life a little bit easier for everybody. Michael, the last 3 panels scored 100% on the polls. So we asked questions, you know, you have to write an exam, so your group, and they got 100%. No pressures, but just to let you know that they got 100%, which is great. And that's really helpful. I know that you also, we would hear from your group towards the end on the poll, we'll do that. And so I'm going to hand over to Michael. Michael is my colleague. His office is just behind me here. And that's his office. And he's my colleague here at SOAS. He is our ADR specialist. He's a mediator. He practices and he teaches and does research in mediation primarily. And so I'm going to hand over to Michael, who would introduce his panelists and proceed with the panel. Michael.
Thank you very much, Amelia, for this opportunity of being with you all today. It's a great pleasure to be with such a distinguished panel with so much wide experience of mediation in many different nations and many different ways. What I'd like to do today is to introduce each of the panel individually, to give them an opportunity to make a presentation. And then I hope we will both have more of a discussion between the panelists and to take questions from the floor. I can't call on you to speak from the floor, so you'll need to put questions in the chat, but please do think of those while you're listening to these presentations. And I'd like to start today by introducing Nigel Kolonde-Matuna, who has been a judge since 2009 and a judge of the Supreme Court in Zambia since 2016. He brings experience both as a mediator and a trainer of mediators, and he chairs the advisory committee on court-annexed mediation. He was also had a deep involvement in drafting the Arbitration Act in Zambia. So I'd like you, if you would, Nigel, to introduce us today to these themes of the role of the state in promoting mediation, both nationally and in a cross-border context.
Thank you very much, Michael. And hello to everybody. By way of introduction, what we have in Zambia is court-annexed mediation. That's on our statute book. That is not to say, though, that there isn't private mediation going on in the country. And this was an initiative by the judiciary with the assistance of the United States Agency for International Development. It started in the year 1997, and it involved the amendments to the High Court rules. Secondly, the training of mediators. Thirdly, sensitization of the legal profession and other potential users of mediation to the process. It is important that I state that in Zambia, the Chief Justice is empowered to make rules that improve the administration of justice. So the amendment to the rules to introduce mediation was pursuant to that power vested in the Chief Justice. Now, my paper will discuss the role played by the judiciary in the introduction of mediation, the impact and challenges, and some of the successes we have scored. In terms of legislative reform, the various amendments were made to the High Court rules between 1997 and 2018. These amendments brought in the following: referral of matters to mediation, those that were on the High Court cause list. The point of referral of a matter to mediation, that is at the scheduling conference, that's at the first point where the judge meets the parties, and the cases that are amenable to mediation. The amendments also provided for the period for mediation and also the list and qualifications of mediators, confidentiality of the process, and the effect of a mediation settlement order, which in Zambia is final and binding on all the parties. Consequences of failure to settle, which is sending back the record to the judge for him or her to adjudicate upon, and the consequence of a party being uncooperative to the process. The last amendment brought in a mandatory referral to mediation in certain cases. Now, coming to the training of mediators, this was done in the year 2000 in conjunction with the Washington, D.C. Superior Courts. And the people we trained were drawn from the legal profession, Bankers Association, insurers, engineers, surveyors, and were drawn from the business community as well. That is the Zambia Association of Chambers of Commerce and Industry. So we have a pool of mediators drawn from various professionals. We also embarked on the training of trainers. So in that light, we also have a pool of trained mediators. In terms of sensitization and public awareness, we conducted various workshops with the key stakeholder, the Law Association of Zambia, and other stakeholders in the mediation process. We also conducted TV and radio interviews highlighting the advantages of mediation and where it is best suited. The institutional framework comprises the mediation officer who conducts the day-to-day affairs of mediation, and my committee, which is the Chief Justice's Advisory Committee on Court Annex Mediation. This is the policy-making body, which comprises of various judges from the various courts and a representative of the key stakeholder, the Law Association of Zambia. What about the challenges? Some of the challenges we've experienced are resistance from the legal profession, because mediation is seen as a reduction in billable hours. There's also some amount of ignorance on what the process entails. All lawyers have a comfort zone, which is litigation. So they more or less shy away from mediation, which is not a familiar turf to them. There has also been a bit of resistance from the Attorney General's chamber. The Attorney General's chamber is important because the Attorney General is one of the biggest civil litigator in Zambia. And the problem here arises from the fact that before any amicable settlement is reached, the Attorney General has to approve it. Then until 2019, we didn't have a continuing education system in place. As such, the standards fell a bit, but now we do have a continuing education process in place for retraining mediators. The other challenge we have faced is inadequate structures for the institutional framework and mediation rooms. This is a common problem in this region, in that the court infrastructure is not sufficiently funded by government. The other challenge I'd like to highlight is judges' failure to follow mediation protocols. We have in place a protocol that judges should follow before they refer a matter to mediation. That is, engage the parties, inform them why they feel their case is best suited to mediation, and that he or she is not throwing them out of his court, but rather asking them to pursue a more suited dispute resolution process with a view that they'll come back if they fail to settle. The mediation fees are also rather on the low side, so that does not attract most mediators to mediate. The other challenge I'll highlight is the need for Zambia to ratify the Singapore Convention, especially in the face of the fact that Zambia is a landlocked country, so most of its citizens are engaged in cross-border trading. As such, a lot of disputes have arisen in that area, and mediation is best suited to those disputes. And as such, if we ratify this convention, it will help stimulate mediation in that regard. We currently also do not have a code of conduct to regulate mediators, but work is underway for implementing that. COVID-19 has also been a drawback in that we have failed to host what we call mediation settlement weeks. As such, most cases lie in abeyance because although referred to mediation, they cannot be conducted due to social distancing regulations. Some of the successes are that we now have a constitutional mandate in that the judiciary must provide ADR mechanisms, one of which is mediation. So we have a multi-door court system now. And mediation is one of our budget lines, and as such is adequately funded by government now. The other success is training and retraining of both mediators and the trainers of mediators. We'll also be hosting very soon a mediation advocacy course for the lawyers to encourage them to resort to mediation. I would end by saying that generally, there's been an increase in the use of mediation in the commercial sector as a result of the initiative by the judiciary. Thank you, Michael. I'll end there for now.
Thank you very much indeed, Nigel, for that admirably clear introduction to the subject and your experience from Zambia. I'd like next for us to hear from Mariana França Gouveia, who combines experience as a mediator and lawyer with being an academic and also advising in a number of contexts the Minister of Justice. She has been the director of audit and mediation, is a professor of the School of Law in Lisbon, and a partner of PLMJ Lawyers. Mariana, thank you so much for being with us.
Thank you very much. It's my pleasure. I'd like to start by saying that it's a pleasure to be here and to discuss with all of you some topics regarding mediation. So my topic here is to address the Angola and Mozambique cases in mediation. So although I'm not from neither Angola nor Mozambique, I'm Portuguese and based in Portugal, but I've been working a lot with these countries. And so the purpose of my intervention is to give some information, issues regarding each one of these countries, a framework, legal framework, some state initiatives that the state have adopted regarding mediation in Angola and Mozambique, that we have collected under the project, under the mediation network project that we have collected. I'm just going to refer some of those data, although they are not still final. So starting with Angola and the legal framework mediation in Angola. Angola has a mediation law that was enacted in 2015, so just a few years ago. It's a very comprehensive piece of legislation regulating the mediation agreement, the mediation procedure, the mediator's rights and duties, and also mediation centers. It has adopted, I would say, it's a facilitative concept of mediation, as it is provided by the law that the mediator does not have the power or cannot suggest possible agreements, and so his role or her role is only to facilitate the communication between the parties. The type of disputes that can be submitted to mediation are, I would say, all type of dispute, as long as they regard disposable rights, so rights that the parties cannot by their own will waive. The fundamental principles of mediation are voluntariness, equality and impartiality of the process and the mediators, of course, confidentiality, which is a very important feature of mediation, and enforceability in the sense that settlements that are obtained through a mediation process then can be enforced as judicial awards or judgments. Regarding the mediator in Angola, they have to be professionally qualified or possess a mediation certificate recognized by the public administration body. So regarding training and, I would say, assessment of the mediators, they have to be trained specifically to be able to act as mediators. Now, going to the second point, which is state initiatives. In Angola, the state has established and funds a center called CREL, a mediation center or mediation or alternative dispute resolution center that offers not only mediation, but also arbitration to citizens and to companies. I would say that this is the only center, as far as I'm aware of, and by the data that we have, is the only center where nowadays mediation is being administered. Of course, there may be cases of private commercial arbitration, but the main majority of cases, or the number of cases that we are aware of, are from this center that has been in place since 2015. It's a public center. It's part of the Ministry of Justice and Human Rights in Angola. And so is organized as a more or less a state department, but not within the courts. So it's not a court annex mediation, but organized by the government and ruled administrated by the government. So this center called CREL has around, in the last 3 years, 500 cases per year. So I would say it's very, it's an impressive number, taking into consideration that mediation is something very new in Angola. And the rate of settlement is around 50%. Mozambique, turning to Mozambique, conciliation and mediation, although this law has much more years, has been enacted a long time, well, 20 years ago, not as in Angola just 5 years ago, but 20 years ago. It's from 1999, in fact, 21. So here the mediation, the definition of mediation, the law defines mediation and defines conciliation, because the Mozambique law is not only on mediation, but also on arbitration and on conciliation. And the law defines the concepts, establishes the concepts for each one of these alternative dispute means for the resolution of conflicts. And here the concept of mediation seems a bit different from what we are used to, at least in civil law countries. And in this case, different from what we've seen in Angola, in this case, the mediators, they are supposed to propose agreements. So their function is not only to facilitate communication, but they should help the parties and propose and suggest agreements, specific agreements to solve the cases, where conciliators may not. Well, there we can discuss from a conceptual point of view, but I think maybe there's some just issue of degree of how intense is the role of the mediator and the conciliator in Mozambique. Again, everything can be submitted, or every type of disputes can be submitted to mediation, as long as this is the same rule as we've seen in Angola, as long as it regards non-disposable rights, or rights that the parties can waive by their will, through their will. The agreements that are reached in mediation are also enforced, can also be enforced, and they are similar to judgments, to judicial court judgments in terms of enforceability. And then I would like to highlight a very specific situation in Mozambique, where in labor mediation, so mediation regarding labor cases, mediation is mandatory by law. So according to a law that has already some years now, parties cannot resort to either to arbitration or litigation before trying to mediate a case in labor, in a labor dispute. This has been one of the reasons why in Mozambique there are so many cases, so many mediation cases. There is a specific center, which is the COMAL, the Labor Mediation and Arbitration Commission, that has centers in all provinces in Mozambique. It was established in 2009. Again, it's a public institution outside the courts, so it has not any relationship with the courts. But it was established because of this provision of the law that obliged parties to mediate cases in labor cases. And there are a lot of cases. This Comal Center has around 7,000, a lot of cases, 7,000 cases per year in the last 3 years, and with a rate, settlement rate really high of 85%. What is also interesting or funny is that this law, so the law in Mozambique that obliges parties to start by mediation before going to arbitration or courts, this law has been declared unconstitutional by the Constitutional Court of Mozambique now several times. And just recently there was a new decision again a ruling that this provision is against, or it's not in conformity with the Constitution, because allegedly it would be a limitation of the right to access to justice. The fact is that although the Constitutional Court has ruled several times in this sense, this is not a definitive, a finally decision, so the provision is still in force, and maybe by culture or by custom, I don't know, by tradition, the parties still resort to mediation. So even though by now they should know that it's not a duty that they have, but they still resort, mainly employees. And then what is said is that the employers, they just go there to just follow their employees. And in a lot of cases, we've seen 85% of cases they are able to reach a settlement. So this is a very interesting or specific fact regarding Mozambique, and that explains the high number of cases, labor mediation cases. Just to finalize my intervention, there's also more recent court annex mediation system in Mozambique. Now, currently only in the Maputo courts. So it started just I think last year. The council resolution, the council resolution judiciary initiative from 2017, but that established or provided that provincial courts may establish mediation services that which will administer court annex mediation. And by now these services exist only in the courts of Maputo, but the success of the initiative is still unknown. We still have to try to find if there are cases and what are the settlement rate and other characteristics. So this is what I would like to start by saying. And of course, I'm more than willing then to discuss other issues I would like to discuss. Thank you very much.
Thank you very much, Mariana, for that fascinating presentation, and very much interesting to hear of the both mandation in relation to labour disputes, but also the constitutional problems that's obviously caused is fascinating. I would love to learn more about that. I'd like next to ask Gaston Kenfack Gaston if he would speak. Difficulties in joining us this morning, but delighted that you're here with us. Kenfack is Director of Legislation at the Ministry of Justice in Cameroon. He is an expert in international economic law with a doctorate from the Sorbonne. He is also the editor of the Revue Camerounais de l'Arbitrage, I'm sorry if I don't pronounce that very well, and a member of the board of directors of the Cairo Regional Centre for Commercial Arbitrage. So kind of has a continental reach to his experience, and was also president of the 49th session of the of Anketral. So welcome. It's a pleasure to have you with us today, and we really look forward to hearing what you have to share with us.
Thank you, Michael, for introducing me. I am really facing technical constraint, but I do hope you can hear me.
We can hear you fine, thank you.
Thank you. So let me first thank Emilia and SOAS for inviting me to attend such an important event. And I understand that I have to make a presentation of the mediation in the OHADA context. And let's begin by indicating what OHADA is. OHADA is the French acronym of the Organization for the Harmonization of Business Law and in Africa. It's currently made up of 15 African countries that are Benin, Burkina Faso, Cameroon, Comoros, Congo, Democratic Republic of Congo, Ivory Coast, Gabon, Guinea, Bissau Guinea, Equatorial Guinea, Mali, Niger, Central African Republic, Senegal, Chad, and Togo. Now, the legal framework of mediation in the OHADA area is made by the Uniform Act on Mediation that was signed by the OHADA Council of Ministers in 2017 in Conakry. And for us here in the OHADA space, the mere existence of this Uniform Act is something very important. It shows that the OHADA legislator has the will to join the international community in promoting mediation as a tool for settlement of commercial and investment dispute. To make a presentation of this Uniform Act, I'll just say that it is modeled on the UNCITRAL 2002 model law on international mediation. And to give a definition of mediation, Article 1 of the Uniform Act on Mediation defined it as any process, whatever its name, in which the parties ask a third party to help them reach an amicable settlement of a dispute, a conflicting relationship, or a disagreement, this arising from a contractual or other legal relationship or linked to such a relationship involving natural or legal persons, including public entities or states. You see, this definition is very close to the one contained in the UNCITRAL model law I have mentioned. The text includes in its material scope mediation agreements agreed by the parties themselves without the assistance of a third party, because I think it's very important to say, while promoting mediation has a mean for the settlement of investment or commercial dispute, the aim of the OHADA legislator was also to promote the amicable settlement of dispute as a whole. That's why even agreement concluded by the parties themselves without the assistance of a third are also considered within the context of OHADA mediation. So in this regard, Article 12D of the Uniform Act states that mediation ends with, and I quote, the written declaration of one party addressed to the other party or to the other parties. And if a mediator has been appointed to the mediator, indicating that the mediation procedure is terminated on the date of the declaration, end of quotation. The term mediator within the context of this Uniform Act refers to any third party requested to conduct mediation, regardless of the name or profession of the third party in the state party concerned. Mediation can here be ad hoc or institutional, and the Uniform Act on Mediation does not apply to cases in which a judge or an arbitrator, a court or arbitration body attempts to directly facilitate an amicable settlement with the parties. Now, what about the conduct of mediation? The parties here are free to agree on how the mediation should be conducted. Failing this, the mediator will conduct the mediation as he considers appropriate, taking into account both the circumstances of the case and the wishes of the parties. The mediator must carry out his mission with diligence and must treat the parties fairly. The mediator does not impose any solution to the dispute on the parties. However, he may, at any stage of the mediation, make proposals to the parties. After consultation with the parties, the mediator may invite an expert to obtain a technical opinion on one or more aspects of the dispute. And here, the mediator means either a natural person or any institution established in one of the OHADA contracting states and offering mediation services. The mediator adheres to the principles guaranteeing the will of the parties. Moral integrity, independence, and impartiality must characterize the mediator to ensure the effectiveness of the mediation process. In addition, the mediator must ensure that the envisaged or chosen solution guarantees the efficiency of the process. In his office, the mediator can hear the parties separately or together while respecting the adversarial proceedings. And if he chooses to hear the parties separately, he or she, I mean the mediator, must ensure that counsel for the other party is present. Now, the party which intends to take an advantage of the mediation is required to provide proof thereof. He can do it by any means. And when the mediation order by the judge or by an arbitrator ends without the parties reaching an agreement, the judicial or arbitral proceeding resume their normal courses. What I intend to say here is mediation here can be ordered by a state court or by an arbitrator, but it is not to say the Uniform Act on Mediation will be applied in this case. Even though, if in this case, the parties are able to reach an agreement, the said agreement should be implemented according to the provision of the Uniform Act on Mediation. And now, let's assume we have an agreement on mediation. How do we implement it? And this is one of the most important provisions of the Uniform Act, how to implement a settlement agreement issued in mediation. And in this regard, the execution of the mediation agreement is governed by Article 16 of the Uniform Act on Mediation, which reads as follows, and I quote again: if at the end of the mediation, the parties conclude a written agreement settling their dispute, this agreement is binding and binds them. The mediation agreement is subject to peaceful execution. At the joint request of the parties, the mediation agreement can be filled in the ranks of a notary's minute with acknowledgement of document and signature. The notary delivers at the request of the interested party a minute or an enforceable copy of the agreement. This is the first hypothesis to implement the mediation agreement. The second case is at the joint request of the parties, or feeling that at the request of the most diligent party, the mediation agreement may also be subject to approval or exequatur by the competent state court. The judge rules by order. He cannot change the term of the mediation agreement. And the competent court has only to verify the authenticity of the mediation agreement and grant exequatur or homologate the agreement within a maximum period of 15 working days from the filing of the request. However, homologation or exequatur can be refused if the mediation agreement is contrary to public policy. In the absence of a decision within the period of 15 days referred to, the mediation agreement automatically benefits from homologation or exequatur. So you see, that's why I was saying that this is a very important provision of this Uniform Act, because either you go to a notary or you go to the state court. And if you choose to go to the state court, you can submit a joint seizure. And if one of the party is not for the implementation, the text allows the party interested to seize the competent state court in order to obtain exequatur or homologation. So for now, let me stop here and just to introduce the debate, and I'm available for further questions. Thank you so much for giving me the floor.
You're on mute, Michael. We can't hear you.
Sorry. Thank you very much, Kenfack, for that fascinating exposition of mediation in Cameroon and the role of legislation in that. And fascinating that the legislation specifically includes that possibility of the mediator making a proposal. And I hope perhaps when we're you're discussing as a panel, I'd be fascinated to know whether that shapes the style of mediation that is adopted in Cameroon. Thank you for that. I'd like to go next, please, to hear from Diamana Diawara. Diamana is the Director of Dispute Resolution Services at the ICC. She has previously been counsel at the Secretariat of the ICC in charge of case management for European and African cases. She is also a lecturer in arbitration at Montpellier University and has trained in arbitration in Paris. So it's a great pleasure to have you with us today, Diamana, and we very much look forward to hearing what you have to say.
Thank you very much, Michael, and good morning, good afternoon, everyone. It's a real pleasure to be here, and please allow me before starting to acknowledge the organizers of this excellent 7th SOAS conference, both Isham and Emilia. You've done a great job with this conference, and congratulations. So what I propose to our audience today is to go over mediation, looking at the question of how African states can better promote mediation in the resolution of commercial disputes through the example of the ICC mediation and more specifically the ICC Center for ADR. I would first go over the landscape of ICC mediation, then tackle the question as to why choose mediation at all for commercial disputes, and then finish my presentation with exploring ways in which mediation can be promoted for African parties. So looking very briefly to give you an overview of ICC mediation. ICC mediation is administered by the ICC International Center for ADR. And under the ICC mediation rules, mediation is a flexible settlement technique conducted privately and confidentially, in which a mediator acts as a neutral facilitator to help the parties try to arrive at a negotiated settlement of their dispute. The parties have control over both the decision to settle and the terms of any settlement agreement. So that definition basically complies with what we heard from my co-panelists before, meaning that mediation is a process that relies 100% on the parties' autonomy, and that the facilitator is there to, as its name indicates, to accompany the parties in that process rather than impose a decision on them. Now, what does ICC mediation look like? When looking at the ICC mediation cases over year 2020, we note that about 33% of the cases we've registered in 2020 were mediation involving parties from the same nationality, meaning this domestic mediation concerning domestic disputes, whereas the other 66% were cross-border mediation cases. In terms of origin of the parties involved in ICC mediations, Africa is by far the continent, the least represented continent in our mediation cases, and African parties represent less than 2% of ICC mediation cases, whereas Europe accounts for almost half of the parties involved in ICC mediations, and then parties originary from Latin America are the second ranked parties participating in our mediation cases, and in third place come the parties originating from Asia and Pacific. With respect to the different economic sectors that we have involved in our ICC mediation, what is interesting to note is that we have exactly almost exact reflection of the economic sectors that we see leading in our arbitration cases, which I will come back to a bit later, but says a lot about the type of cases that mediation is able to resolve. So the disputes concerned in ICC mediation are from a wide range business sectors, from construction and engineering, which are the top economic sector coming out of our dispute, refer to mediation and account for roughly 24% of the cases. These are immediately followed by disputes relating to the energy sector. There again, we find the same ranking in our arbitration cases, and then comes in the third place the telecommunication sector for our ICC mediation cases. In 2020, the value of disputes handled by the ICC Mediation Center ranged from a few thousand US dollar. The ICC always, the currency used by ICC, both in arbitration and mediation, is the US dollar. So those cases would range from a few thousand cases, few thousand US dollars to over $800 million in a given case. And we have an average amount in dispute that is around 66 million US dollars. And I think that information confirms that mediation is a very suitable means of resolving complex disputes with high financial stakes, and in complex business sectors such as constructions, which we know by definition is quite disputes heavy as an economic sector. In terms of cost now, the ICC mediation average cost, I would say, is in the range of 20,000 US dollar, and that is covering both the fees of the neutral, either selected by the parties and confirmed by the ICC, or the neutral when it's he or she is appointed by the ICC directly. So that covers both the fees of the neutral and the institutional costs. Now, that gives us an idea of what ICC mediation looks like. What I would like to come to next is why choose mediation for commercial disputes. I was telling you a few moments ago that we can see when looking at the characteristics of those cases that the ICC handles, and 2020 was a record year for the number of new mediation cases registered with our center. We can see that extremely complex disputes with high amounts at stake can be resolved by way of mediation. And the interesting thing, of course, with mediation compared to arbitration litigation is that when you look at mediation, it not only offers an efficient way of resolving the dispute under the ICC Mediation Center, but it's also at a low cost and, more importantly, with a high success rate. When you look at the different cases involved with ICC, the different mediation cases, we note that in more than 50% of the cases, the mediation will succeed with, the outcome will be a settlement between the parties, which makes it a very important success rate. And in more than 90% of ADR and mediation rules, more than 90% of our ADR and mediation rules users indicate that they will include a mediation clause in their contracts in the future. And that is regardless of the outcome of their mediation. So it definitely is a dispute resolution mechanism that allows to conserve good relations between the parties, that is extremely efficient in terms of time. At the ICC ADR Center, we have an average duration of the mediation of less than 4 months from the receipt of a request by a requesting party until the conclusion of a settlement agreement. So that also includes the steps of finding the neutral, appointing him or her, and then holding the mediation sessions with the parties, either jointly or separately. So we have an average of 4 months to resolve disputes that range from a few thousands US dollars up to hundreds of millions of US dollars. And that makes it, as I was saying, a very, very efficient way of resolving disputes. And last but not least, mediation, as opposed to ICC arbitration, is always confidential. I remind you the definition I was giving you in opening. The ICC mediation rules define mediation as a flexible settlement technique, which is conducted privately and confidentially. Such confidentiality does not automatically ties to ICC arbitration. Parties would have to specifically agree to confidentiality. So I often refer, when talking about mediation and what's the interest for parties of mediation in commercial disputes, and I would say in complex commercial disputes, such as the ones that ICC is entrusted with on a daily basis. I often refer to the words of Senegalese Professor Abdullah Cissé, who was, when talking about mediation, always saying it has this advantage over arbitration, that where mediation will untie the knot that the dispute creates, arbitration would cut the same knot. And by untying the knots rather than cutting them, mediation allows to save the rope, right? You can still use it, you can still do something with it, the rope, sorry. Whereas with arbitration, it's broken. And that is why a very high rate of our ADR mediation rules users would include mediation clauses in their contracts in the future, because they know that then it allows them to continue their business relationship. And after all, what business actors are, economic actors are looking for is for efficient methods to resolve the dispute and allow them to continue their main purpose, which is their business activity, not disputes. Disputes for them is not, it is our main activity, it is not theirs. Their purpose is to get the dispute out of the way so that they can continue conducting business, and mediation allows that. Now, Nigel, sorry, Michael, if I have a few more minutes. Yes, so now coming to the question of how and why African states can and should promote mediation. I would like to make again here a parallel with arbitration, and looking at the shape of ICC arbitration cases involving African parties, and in particular African state parties. I think there's a big case to say that African public and private actors would gain a lot by having a more intensive recourse to mediation rather than arbitration. if you look at ICC arbitration cases involving African parties, roughly, I mean, a little less, sorry, than 40% of African parties involved in ICC disputes are state parties or state-owned entities. And when you look at the type of cases in which they're involved, those parties are in more than 60% of the case in a responding defendant situation, meaning that they are brought into the arbitration by their opponent. In those cases, we also see that the outcome of the arbitral proceedings in a wide majority of the cases will be a decision unfavorable to the African party. And those cases for the vast majority would concern extremely important projects involving natural resources, infrastructure projects, construction, energy, as in mediation. And so when one looks at that, it's very easy to come to the conclusion that with a mediation that would avoid a decision imposed by the outside, by an arbitral tribunal based on the law primarily, rather than based on the interest of both parties, and not just the interest in saying I am right and the other party is wrong, but the interest in preserving the relationship and allowing, as I was saying, the activity, the business activity, the project to continue rather than end after a decision. So when looking at these different elements, it's very easy to conclude that by going through mediation, African parties would be able to save, I think, a very high amount of money from damages award that would be avoided. It does not mean that they would not have to make themselves concessions. That's the whole point of mediation. The settlement includes that both parties would have to make compromises, but probably and most likely that compromise would be financially more interesting, and more than financially also in terms of the continuation of the relationship, saving face, more interesting than what arbitration allows for. And that's why I think that definitely for the African continent and African parties, where we see increasing business activities and from the state's perspective, in situations where the state is contracting for private activity, or with private agents, but for the purpose of conducting projects that that are of public interest for the general public in their countries. Mediation is, I believe, a very interesting dispute resolution method that should be explored. How to do it now and how to make it more efficient, maybe we can save that for the discussion with the rest of the panel, Michael. But I would already mention one of the idea, obviously, is the mandatory pre-mediation step that I think Nigel has referred to, which obviously has the benefit of at least putting both parties in a situation where they sit at the table. It does not mean that the outcome would be a positive one and that a settlement agreement would come out of it, but at least the attempt is there, and potentially saving a lot of time and cost than if the parties were to go straight to arbitration or litigation. I would also say that there's definitely a need to infuse a mediation culture generally in African states, because that's what we're talking about. That's the region we're talking about. I actually believe that in terms of business, it would make sense for a lot of different regions to use the same approach. But and by mediation culture, what I mean by that is that by, for example, having mandatory trainings on mediation for lawyers or for judges, as well as focusing on the young minds and having in university curriculums future lawyers trained properly in mediation. They are going to be the future advisors of businesses, and by being acquainted with the culture of mediation from their studies, the chances are higher that they will, try to foster that spirit of mediation with their own clients. So I think there are different angles with which that can be taken, and I'm welcoming